Sir, it's a pleasure to rise on behalf of New Zealand First to speak on the Children, Young Persons and their Families Advocacy Workforce and Age Setting Amendment Bill. At this stage, we will be supporting this bill, sir. We agree with the majority of the bill. However, we do have some reservations, a few questions and a few issues that we'd like to address. Some of them are highlighted in the departmental report, some of the evidence and the submissions that were given during the Select Committee process, and a couple actually were already mentioned and spoken about by a couple of other parties earlier on tonight, sir. So the five aims of this bill that we've heard about today, sir, we agree with four in its entirety, and we have some concerns with one of them. The first that we obviously agree with is the fact that this legislation actually extends the state responsibility for care and protection to the person's 18th birthday. We agree with that, sir. It also encourages the participation of children and young people in decisions that could significantly affect them. It is ensuring that wherever possible, policies and services have regard to the views of children and young people, and we agree with that, sir. And supporting the setup of independent advocacy services with a particular focus on children and young people in care, we also agree with. But the fifth one, sir, which has been mentioned by the opposition already today, is the fact that one of the aims is to allow a broader range of professionals to perform a wider set of tasks to help identify meet the needs of vulnerable children and young people. And unfortunately, the detail that they have there in that aim, that one sentence, is probably the extent of the detail with which the clarity of which is in actual legislation, and that's one of the problems that New Zealand First has, is that it's so ambiguous and so wide-ranging and so wide-sweeping that the Minister can stand up and talk about the supplement of or help to the social workers that we'll get from professionals such as in education or health sector. But the problem with that is a double-edged sword, because what the opposition is trying to highlight is the fact that it could be anybody, that it could be the entire slippery slope and the first step down the privatisation pathway. And that's exactly what New Zealand First and the opposition are disagreeing with, sir. I'd just like to read a sentence that is in the introduction. It says, the bill seeks to achieve this last point, which is the point I was just mentioning about the allowing broader range of professionals, by making the Chief Executive responsible for many tasks that the social workers are currently responsible for. And what the Minister was actually trying to imply was that the Chief Executive would be supplementing the social workers' tasks and not replacing them. But the fact that in that sentence it says that it would be responsible for many tasks that social workers are currently responsible for, that is a direct replacement of what the social worker tasks are, not supplementary. And in fact, sir, that comes in total contradiction to the mandatory registration rhetoric that the government and the Minister is standing up and wanting. The government on the one hand says that we need mandatory registration of social workers because it maintains standards, safety, qualification, security and robust regulations. But then on this, and within this legislation, sir, it actually disregards that entirely. And what it does is obviously highlights the overarching, once again, social investment approach that this legislation will be encouraged by. I'd like to actually mention, I wasn't going to speak too long on it, sir, but it has been mentioned by the Labour and Green Party about the issues that they have with the age of the youth justice system not matching the protection and age of, well, lifting the age and care of protection. And it's quite frustrating to hear a lot of ideology and rhetoric, but not a lot of facts and data and research to back it up. Well, unfortunately, in the Labour Party's minority report, they state that they disagree with the bill's move to separate care and protection from the age of the youth justice system. And the question that I put to the Labour Party is that now you've got youth advocacy groups just like Just Speak who want to increase the state of the age of care and protection to 21. Now, is the Labour Party saying that they would want to back the youth justice system age to 21? Because it's exactly what the first sentence says in the minority report. They also say that, and the Greens say it as well, that we're breaching UN conventions. And that is absolutely not true, sir. Because when we signed the UNCROC, We signed it with reservations. We signed it with reservations. And I can quote it. It says the Government of New Zealand reserves the right not to apply Article 37C, which I've mentioned in this House previously. And that Article 37C has got to do with the youth justice age and the mixing of with children and with adults. I mean, it states it right there. It's not hard. It's not hard to do the research. The second point, the major point that the Labour Party and the Green Party are wanting to make about the youth justice age, sir, is that it's going to, what do they say? They say it's going to present practical difficulties and administrative complexity. Well, where's the evidence that that's going to happen? Where is the evidence that that's going to happen? The fact of the matter is, I specifically asked officials in the select committee, sir, if this would actually create a burden, a bureaucratic burden, or a bureaucratic nightmare that the Labour Party and the Green Party have been spouting, and they said no. They said that the different ages of the youth justice system, with the age of the state and protection, the age of care and protection, would not create any administrative issues. Would not create any administrative issues. Well, and one of the other things, sir, just lastly on this point, before I move on, is the fact that the Greens said that there was, did not hear any argument to justify continuing the lower age for youth justice. Well, how about the fact that the youth justice system is failing quite demonstrably, and the fact that the government has had to fork out, $1 billion to extend the number of prison beds. Now, the fact is that half of all current adult prison population have gone through the youth justice system. And if the youth justice system was actually working, then we wouldn't have the need to extend and spend $1 billion on extra prison beds. It's that simple, sir. I could go on that point for the rest of my time and longer, sir, but I'll just want to quickly mention a couple of the issues that we have with the delegative powers. And actually, the PSA were the ones that stated it the best, and in regards to the stance that New Zealand First has with this. And they stated that the core and unique role of social workers will be gradually eroded over time, with social workers gradually being replaced by a range of professionals untrained in statutory child protection work. This will lead to a tremendous loss of knowledge, skills and experience, sir. And if we actually have a look at the legislation itself, like I stated right at the start, sir, it is the way that the legislation is actually written is very vague, it's very ambiguous, and it's a double-edged sword. And I'd just like to highlight section 7, and in particular 7C, and it states where the requirements for delegation to persons who are not social workers. So this is where the delegation is given to people who are not qualified social workers, sir. And before making a decision to a person who is not a social worker, the Chief Executive must be satisfied that the person is appropriately qualified to perform the function or exercise the power, taking into account the person's training, experience and interpersonal skills. And then, however, it goes on to say that the Chief Executive may make a delegation to a person who does not meet the requirement in subsection 2A, which I just mentioned and just read out, if the delegation is made for the sole purpose of that delegate subdelegating the function or power to a person who works under the management or supervision of that delegate. So now, what the provision states right at the start, which was the 7C2, sir, about the need of the person to be suitable, even though they're not qualified, but suitable for that role, it goes on to say that if that delegation is subdelegated, now it's totally irrelevant. So we've got a few questions in the way that the legislation is written, sir. We've got a few concerns with the fact that this could be the slippery slope down the pathway of privatisation. We've heard Serco mentioned. We've got serious concerns and issues with that. And we've also got our strong views on the youth justice system, sir, and the age remaining the same. And New Zealand First is in part of has the view in regards to the youth justice system age that we will not be entertaining any sort of conversation that wants to extend that when the system itself is failing in the first place, sir. We will be continuing to support this bill at this stage, sir, but we would like to have our questions, concerns answered throughout the rest of the process. Thank you, sir.